So you've heard from people that have been here for 14 years, 32 years. I'm a new resident of Caroline, just signed a lease, not a gas lease, a lease to live here. Just signed one, okay? And so that's why I'm here tonight. This resolution that we're discussing tonight is infuriating to me. People have talked about that it's not democratic, so I'm going to skip over my part on that because that's been talked about. So my second point would be that the two members who have brought this to the board and then another who has said that he supports it have a definite and very obvious conflict of interest in this issue. Two personally have land that is leased to gas companies and then being in charge or directing the Landowners Coalition, which is trying to get a large group of landowners to lease in a block. I'm not sure how that's not a conflict of interest with this resolution. Regardless of my opinions on whether fracking should or shouldn't be allowed in Caroline, these people shouldn't be voting on this resolution. They should recuse themselves. So ideally, the resolution would not even be voted on. But if it was, I said that they should recuse themselves. Sorry. The last point that I would make is that the town of Caroline has an approved comprehensive plan, which keeps Caroline as a rural place with farms and small businesses and no heavy industry. Natural gas drilling is clearly heavy industry. If we look anywhere that it has been happening already, Pennsylvania, Colorado, wherever you want to look. So in short, the resolution is undemocratic. Multiple members have conflict of interest, and it clearly goes against the approved comprehensive plan for the town of Caroline. Thank you.
Schmidt and then Tony Tabelli.
Good evening. My name is Irene Weiser, and I've been a resident and property owner in the town of Caroline for the past 15 years. I spoke at last week's agenda setting meeting about my displeasure with the resolution offered by Ms. Adams and Mr. Hoyt, and I asked that the resolution be withdrawn. My request was denied. I expressed concerns that the resolution was misleading and that it implied that it had the support of the town's attorney, and I wasn't sure if that was true. I also expressed concern that the resolution was inadequate. Surely, I thought, there must be more this community can do to protect its water and its residents than just enacting stormwater resolutions. Can't we take action to protect us from pipelines placed on our property by eminent domain? Can it protect us from underground storage of gas and disposal of toxic solid waste produced by drilling? What about other forms of pollution? Can't we do more to protect our roads and our hamlets from the disruption that truck traffic will cause? If this resolution passes, it will prohibit any of these solutions from being brought to the board for consideration. And where, oh where, was the due diligence that should have been performed on exploring these questions before this resolution was brought? Most of all, I am concerned by the anti-democratic nature of this resolution, the disingenuous remarks made by its authors, and the conflicts of interest of its supporters. At last week's meeting, we were told that the purpose of this resolution was to spare the board from wasting its time on fruitless discussions about a ban when the law was so clearly established. Yet, as has been demonstrated tonight, the law is clearly unsettled in this area. What's more, and as we've heard, other towns in this county, in response to similar petitions, have been researching ways to enact a ban. Why the rush to preclude our town from doing likewise? And since when is responding to the legitimate concerns of a large number of residents over the most life-altering activity ever to impact this town considered a fruitless discussion? We were told last week that the board had a fiduciary responsibility to protect itself from litigation that would follow from enacting an illegitimate ban. Yet what of the costs of doing nothing, as this resolution proposes? What of the cost to the residents of this town whose property values plummet because of contaminated water? Of the tax revenue lost to the town as property values decline? What about the cost the town will incur for cleanup and pollution spills and toxic spills? What happens if drilling here contaminates 6 Mile Creek and the water supply of Ithaca that runs through Caroline? What liability will we face then? What about the cost of lost businesses, all the wonderful farmers like Anna, who are producing beautiful food that will have to close up because of contamination or the perception of contamination as is happening now in Pennsylvania? And what are the costs borne by each and every resident for the health problems that we and our children will be at risk of contracting? Finally, and most disconcerting are the conflict of interest of the 3 of our board members, whom at least as of last week, indicated their support for this resolution. Mr. Hoyt and McDonald, whom I believe, and I'd like to just kind of hear from you on this as a question to correct if I'm wrong, but is it true, Pete and Toby, sorry, Blake, that you guys both hold leases in this town? And yes, Pete, you as well. And Linda, is it also true that you head up the Tompkins Landowners Coalition, which helps landowners get the best leases possible?
Irene, I would qualify that. It's a public record that I have the Landowner Coalition together. And, you know, the coalition is for responsible drilling, which isn't that different than being opposed to...
Okay, yeah, I'm just about done.
Absolutely, yeah, that's public record. I definitely am.
Okay. These conflicts, whether actual or perceived, leave me and I suspect others wondering whose interest does this resolution serve, the town's or the legislators? Quite frankly, this legislation appears to make a mockery of this treasured thing we call democracy. It is as disingenuous and deceptive as the leases which many unfortunate landowners have signed and now regret. So I am very appreciative, Mr. Krogh, for your attendance here tonight. And I am heartened by Mr. Slottje's remarks about his confidence in your work. It appears to me there's a lot of work to be done here before this resolution should be brought to a vote, and that most likely it should not be brought at all. I urge the board to defer consideration of this misguided resolution until legal counsel from our town's attorney is obtained.
I apologize. My name's Todd Schmidt. I am from Brooktondale. I've been here for 17 years, so I still recognize that I am a newcomer. In deference to the passionate statements that I made before me, this might be a little bit boring, but it will be quick in that I want to talk about process. I'm opposed to this resolution on the grounds that it is unnecessary and unnecessarily restrictive of potential future activities of this board, regardless of what your individual stances are regarding gas development in the town. In particular, the last 2 resolve statements are things that this board has the understood authority to do and act on as the need arises. This was the stormwater and local roads resolution. There is no clarification via resolution that is needed here. Further, I see no reason why the statement in the first resolve statement is appropriate. With all of the new and emerging information that is arriving at our doorsteps, and why would a board beforehand state that they will not act in one way or another in the future? As my representatives, committing to do nothing in the future is not what I voted for. New information arrives in markets every day that affects how each one of us will act and respond, and I encourage the board to do the same. This resolution unnecessarily ties your hands for the future unless changed by another resolution. So what's the point? In whose interest does this serve? And I encourage you to stay informed, stay active, and act when necessary to support and represent your constituency.
Becky DeWitt should come forward, please.
I get to announce myself?
You do, please, Tony.
Oh, there you go.
No, they didn't hear that.
Well, I support this resolution on the grounds that I don't care to get involved.
Your name, Tony, and speaking.
Tony Tavalli. And I support the resolution on the grounds that I don't care to get involved in a lawsuit that is unnecessary. Until we find out whether we have regulatory authority or not, I think we should stay out of it.
Oh, Candace.
Ah, Bruce, you unplugged me.
No, don't take it for sure.
Won't be the first time.
Well, you stop the clock, right? I'd like to address your petition. I'd like to address the petition. I sent this letter to the board, and there was two letters that were two citizens that were concerned about how this was handled when you came to them. And I will read this one from the audience. To whom it may concern, I am a concerned citizen of Tioga and Tompkins County in regards to gas drilling. My concern began when my parents, landowners of 60 years in Brooktondale area, were put in a very uncomfortable position and an uncalled for confrontation by two young people, which were not landowners nor from the Brooktondale area, came to my parents and proceeded to confusion on the subject of gas drilling. My parents of 80 years old have not, like older others, kept up on the gas drilling details. This confrontation created my parents to feel very uncomfortable and knew they were being presented with this in an unfairly and unprofessional manner, especially with very little informational backup. Hence, my parents asked questions, the answers weren't there. End result, because my parents were feeling so uncomfortable, they signed the petition just to get the people off their land. Although each citizen has a right to their own opinion, this property my parents still live on has been in my name since 2008, and if there's a petition to be considered pertaining to my property, I would appreciate it if they would confront me, not my other family neighbors. Since this disrespectful event, my parents, my wife, and I have done some more research and are not against gas drilling. We would like to have their signatures, Solon E. Ogden II and Marion L. Ogden, disregarded from any petition in which holds above complaints. Now, since this was brought to me, I decided to look into this. So I emailed Peter Briggs from the DEC in Albany, and this is what I wrote to him. Hi, Peter. Tony from the Town of Caroline Planning Board, Tompkins County. If you could help me out, I'd appreciate it. There is a group in our town going door to door handing out information in impending natural gas development. Their goal, signed petition banning fracking. My question is this factual information? And the information I sent, there will be 308 wells in Town of Caroline. 2% of the wells will be bad or pollute aquifers. That means 6 wells will be polluted, 6 pools of water, and affect possibly hundreds of people.
30 seconds.
You will have, you will have all your water needs trucked for the rest of your life. Show a picture, and I'll give you his response. You'd be interested to hear what he had to say. And remember that the DEC is bound and gagged. They're not supposed to take a position on this, but Tony, people are going to spread whatever they want to make their case. As you may know, the revised DSGEIS on oil, gas, and solution mining regulatory program for well permit issuance and horizontal drilling and high vacuum fracturing to develop Marcellus Shale and other low permeable gas reservoirs is scheduled to be released by the DEC this summer, followed by public comment period and possible public hearings. Everyone will have the opportunity to provide additional input, and the ultimate goal is to release a final document that lays out the facts, provides mitigation measures where necessary, and ensures permitting and drilling of wells will be conducted with appropriate environmental protection and public safety measures. And I would suggest that we wait for them to do their work. Thank you.
Michelle Brown. You can't read this. Michelle Brown. Come forward.
I'd like to respectfully request that since what Rouse is doing was sort of, I guess, I don't know, slammed on there, I would like to make a response.
No, I think we're just people are saying their piece. It's just what people's piece is, so I think we're not going to have it back at this point. So,
I have a written response for the board, which I'll give them later then.
Okay, I just have Bruce Moran, resident of Caroline, 59 years. I have a question for the board as far as, so keep me off the clock. Critical environmental areas, are they protected under this? Doesn't say anything about them.
We found out from Tompkins Planning that critical environmental areas really didn't have quite the oomph that we were hoping at first.
So we put months of work into critical environmental areas.
I was one of the letter envelope stuffers in that room too, and it just turned out to be a notation, but it didn't have the authority that we had hoped.
Well, why wouldn't critical environmental areas be in this then? Why wouldn't that have been added to this?
Okay, so why'd you
along with roads, why wouldn't you have added critical environmental areas? Since we went through the study and the document and map them.
Well, critical environmental areas can be. I mean, that's our right.
Well, it seems like it should be in here. If it,
So Bruce, make your point. You've got.
I'm just saying critical environmental areas should be in this. We put a lot of time into it. Critical environmental areas should be protected, and it should say something about them in this. And as far as I got off track here, but first let me tell you wholeheartedly, I thank people on both sides of the aisle, because education is what's doing what we're doing right now. It's getting us where we need to go, and hopefully, if it does go down, possibly it'll be regulated the way it should be. Okay, back on track here. This also goes on and on about, surface runoff, and that's all it says is the runoff, which is far, it should be a lot stronger than that. And really the reason I came here was just to talk about democracy, because as far as I'm concerned, this is so far from democracy, it makes me sick. There's a huge conflict of interest on the board, and whether you think there is or isn't, you should step back and look at it. And I implore the board to take the attorney and go over this thing, and if you're going to come up with something with some teeth and something that really means something for the town as the whole population, and listen to what everybody has to say.
Yeah.
David Carver. Go ahead. Name?
My name is Rebecca DeWitt, and I have a question. Is it possible for me to cede part of my time to Bill PODULKA?
Absolutely. Sure.
I had a whole presentation written here that most of which has been covered by other people. My husband, Steve DeWitt, couldn't be here tonight because he's away for a conference, but our entire family is very much opposed to this proposal. And so I want to speak against the resolution for, one thing that I think really hasn't been, well, two things that hasn't been spoken about. First of all, we can talk about the importance of the environment, and that's the reason we moved here, frankly, is because we loved the rural character of this town, and we felt that the planning board did a really great job of defining, where this town would be going. And so now it feels like after we've invested in, property and all that, it's like a 180-degree turn. Most of you have heard the term compulsory integration. When the landmen came to our door, my husband had the good sense to say no thank you. But what we did find out was that people who own the land directly behind our house and directly across the street from us both lease the surface rights. So what that means for us right now is if we decided we wanted to move out of Caroline, which we really don't want to do, we like it here, is that we could very well have a difficult time getting a mortgage on our property, even right now, because gas drilling is considered imminent. So, that's a huge problem for many individuals. One thing I'm going to say very briefly is that I went through the training that Rouse put together, and it was a wonderful training. We spent, a good portion of our time talking about how important it was to to be very respectful of, people who were, not inclined to sign the petition. So, Bill, that doesn't leave you with much time, but I just needed to get that in there because, I honestly don't believe that anybody went to 80-year-old people who might not be understanding what was going on and forced them.
Okay, I'm afraid you used every time.
Oh.
That's fine. Nellie Femme Farnham. No, well, you go ahead.
Oh, you go ahead. I'm sorry, I didn't know.
Michelle, and then David, and then
well, I think everybody has said.
Your name?
I'm sorry. I'm Michelle Brown. I'm a Caroline resident. I'm a landowner. And I think everybody has said everything I'd like to say, especially Rita Rosenberg. And I appreciate that other people brought up the fact that the natural gas is often being shipped overseas and it's not staying here. But that's not really what we're debating. What we're debating is this resolution. And I want to say, I think Mr. Krogh made an excellent argument for why it's premature to make any resolution at this time. And I don't understand the impetus on the part of some board members, which I am going to repeat, I believe have a conflict of interest, or it appears that they have a conflict of interest. So I guess my question is, why the rush? We're not debating, the ban on hydrofracking yet at any time. It seems to me at that time you can bring up your resolution. I agree with Mr. Krogh that it's time we need to take the time and really examine the issues. And if I have any time left, I see them to Bill PODULKA.
I think we just need to keep going. I'm sorry. If we start letting people come in and out, it's never going to work. So Jonathan Comstock should come forward.
I thought I was told that you could see a minute.
Well, that's when I thought there was actually going to be time left.
We have many more people who want to speak than are going to have a chance to.
That's fine.
I'm sorry.
My name is David Krogh, and though I don't live here, I house sit here frequently, and so I'm representing the people whose house I'm sitting at, 1036 Snyder Hill Road. And as we're talking about birds, Steve Cris, who lives there with his wife, is a very renowned ornithologist, and many people have gone through his bird class. So Steve is in East Egg Rock in Maine, and his wife is in Colorado today. Well, this is some issue, and I really want to address several things here. On Monday, I don't know if you know it, but the Supreme Court, the case involved Michael Kerrigan, a member of the city council in Sparks, Nevada. The State Ethics Commission began investigating him in 2005 after he voted to approve a hotel and casino project by a company in which a longtime friend and his campaign manager has served as a paid consultant. This comes from Reuters News Service. This very Monday, the 13th. States can require that lawmakers disqualify themselves from voting on matters because they have a conflict of interest. The Supreme Court ruled on Monday in upholding a long-standing ethics rules. The High Court unanimously upheld the Nevada Ethics in Government Act, rejecting arguments it was unconstitutionally broad and violated free speech rights. The state law requires elected public officials to recuse themselves from voting or from advocating for or against any issue in which they appear to have a personal conflict. Appear to have. You don't have to necessarily, you can have the highest ideals, but if you appear to have a conflict of interest, you should not be voting and you should recuse yourself. Justice Antonin Scalia said in the 12-page opinion that the Nevada Supreme Court had been wrong in concluding that voting by a public officer was protected speech under the First Amendment of the U.S. Constitution. Our history of limiting legislatures' ability to participate in matters in which they have a conflict suggests that the First Amendment has no application to voting by legislatures, he said, summarizing the ruling. The House of Representatives, in its very first session, alleged a rule that no member should vote on a matter in which they have an interest, Scalia said. Also, conflict of interest rules for judges date back to the nation's founding
30 seconds.
And states have a long tradition of such rules. The fact that a voice is the product of a deeply held or highly unpopular personal belief does not transform it into First Amendment speech, he said. Okay, here comes from the Cris. Caroline is a predominantly rural community with small businesses and farms and no heavy industry. The town board is duty-bound to follow the comprehensive plan that strives to keep it this way. That this resolution means they have given up on doing so. Our home is on well water, which our 3-year-old drinks. I'll stop there.
Caroline, a former town board member, and together with my partner Jack Booker, we put our 100 acres recently into a land trust with the into a conservation easement with the Finger Lakes Land Trust. I'm seeking to ask for withdrawal of this resolution. On May 27th, I left for a 12-day vacation. Prior to that, I had followed town board actions relative to gas drilling and had participated in the door-to-door petitioning to ban hydrofracking during the spring. At their May meeting, the town board had been informed about this petitioning. In May, no time frame had been set for any definitive decisions by the town board about hydrofracking. I returned on June 9th to learn that the present resolution was to be voted on at the June 14th meeting. In less than 2 weeks, there had been a fast forward without citizen input. I feel dismayed by the irresponsibility of abruptly shutting down all but this approach for dealing with hydrofracking and discounting, without even hearing any presentation, what has been learned through the spring petitioning. Effectively, this resolution bans the possibility of a ban. A suggestion has been made that this resolution was kind, quote unquote, to those of us who had been petitioning, settling the issue immediately, thus saving us time and energy. This sentiment is off the mark. I will say for myself, and I know I speak for members of Rouse, don't worry about our energy. It's been incredibly energizing to have visited so many citizens of Caroline, to learn firsthand their deep level of knowledge of these issues, their level of concern, their level of support for a ban of hydrofracking in the town of Caroline. So in closing, I have 2 requests to the town board. First, to Supervisor Barber. As one of the co-chairs of the Tompkins County Council of Governments, I ask you to have that group consider issues of conflict of interest for these kinds of decisions, given that government leaders throughout the county will be involved with such decisions. The ruling by the Supreme Court this week provides clear guidelines for all levels of government. Second, I would ask all Caroline Town Board members to lead us in a constructive dialogue and debate, focusing on the future of hydrofracking in our town. We are ready. The citizens of Caroline are informed, they care deeply about the future of Caroline, and they want a solution that works broadly for the citizens of Caroline. The expertise of the town lawyer, together with the expertise of other lawyers in our county and state, are critical for understanding alternatives, as both lawyers have commented. The tradition of home rule in New York State, combined with a specific vision for Caroline as outlined in our comprehensive plan, gives us powerful tools when faced with a level of industrialization that has never been envisioned for our town. It is irresponsible and an outrage to citizens of this town to fast forward the process and to prematurely truncate the decision-making process. The resolution is premature. I call for its withdrawal.
Come forward, and anyone who's not a resident is automatically moved to the end of the list, unfortunately. So just to let you know.